Hi, my name is Josh Gorski. I'm a partner here at Mandelbaum Barrett. I specialize in commercial real estate. Welcome to the May webinar of the New Jersey Restaurant and Hospitality Association. On our agenda today, we're going to talk about commercial real estate, more specifically commercial leasing. As owners, operators of restaurant facilities, some of you may own your properties, others may lease. Before we get started, a couple of general comments and guidelines to frame our conversation today. One, leases are living documents. They survive for the duration of your occupancy of your location, meaning they're to be taken seriously. Unlike a purchase and sale agreement or other types of agreements which will terminate at some point, a lease will survive for the duration of your time in the space. Two, it's important to understand your leverage. Are you a big tenant, a small tenant? Are you the only tenant? This will help guide your negotiations with the landlords. Three, how did I decide what we're going to talk about today? Leases can be 10, 15, 20, 30, 40-page documents. So what's important enough to make our 20-minute session? I focused on two items, money and control. Things that'll cost you money are important. Things that will limit your control are important. First, you have to be able to do what you want to do in the property. Some uses are permitted by law. Other uses are permitted by special permission from the town that you're in. Before signing a lease, you have to make sure you're able to operate your restaurant in that space. It may seem obvious if there's an existing restaurant in that space already. Some may assume that you're allowed to continue that use or open a new restaurant in that same space. That shouldn't be assumed. Two, once you move into a space, depending on the nature of that space, you want to make sure that the landlord cannot or won't open up one of your competitors next door, or even on a property close by. So something important to consider in connection with the use is the exclusivity of your use. Some leases have the ability for you to block the landlord from leasing to your competition within that property or within a certain radius around your property. Term. Understand the length of your term. Understand if you have any options in your lease to extend your term. If you're going to be investing time and energy into your space, you have to make sure the lease is long enough for you to make that investment back. Typically, we see leases run for a minimum of 5 years, but if it's new construction or you're building out your space, you may want to push for at least 10 to 15. Three, if you are opening up a new restaurant in this space, understand how the construction components may work. Sometimes tenants take over existing restaurants, other times they build out a new restaurant space for themselves. If you're building out a new restaurant space, or sometimes even if you're outfitting or retrofitting another old restaurant space, you'll need time for construction. While you're in that space fitting it out to your specializations, should you be paying rent? The lease has started, you have the keys, you're building out your space. How do you have the cash flow to pay rent? Typically, either you're coming out of pocket or you're negotiating some sort of a delayed rent commencement with the landlord. So in this section, it's important to understand when your rent obligations start. Will there be a delay? Will there be an abatement? How long is the abatement? What things affect the abatement, etc. Understanding this series of dates and milestones is super important because a lot of the terms overlap in your lease agreements. Commencement date, effective date, rent commencement date, etc. It's important to really spell these things out clearly. Another way for a tenant to recover some of the expenses that they spend on the space itself is through a tenant improvement allowance. A TI allowance, as is often called, is when the landlord picks up a part of the bill to help offset the cost of the improvement of the space made by the tenant. For example, if you move into a vanilla box, as they call it, or just a sheetrock space, and you have to invest in the walls, the floors, the ceiling, all of the non-tenant specific items on the infrastructure side, the landlord very often provides a credit for that to you because you're helping them improve their space. Something to keep in mind. Three, how much are you paying? What is your rent? Rent, although it seems straightforward, is comprised of a couple different components. There's base rent, which is the same number every month. Some leases have something called a percentage rent, which is calculated based upon your gross sales. Then there's additional rent. Additional rent is everything else you're paying to the landlord. That's not base rent. Additional rent could be taxes. Additional rent could be insurance. Additional rent could be late fees, etc. Staying on the topic of money owed to the landlord as additional rent, depending on the nature of your property, meaning whether you're in a standalone space, in a shopping center, in another type of building, common area maintenance is something you should be aware of. Common area maintenance charges are essentially the charges that you pay to landlord for the landlord's upkeep of the property that you're located in. For example, if you're located in a shopping center, the landlord has to pave the parking lot, they have to light the parking lot, they have to provide fire protection services, etc. Depending on the number of tenants located in that shopping center, the landlord's costs get dumped into a pot, chopped up, and divided by the amount of square footage each tenant has in the center. All this is to say, understand what you're paying every month. Many tenants get lulled into a sense of safety and comfort using base rent only. They have to take into account percentage rent, if applicable, or additional rent to get the true picture of what's owed every month. Next item on our list is repairs and maintenance. Again, heavily dependent on the structure of your property, how it's situated via standalone or shopping center. The repairs and maintenance obligations can vary greatly. Understand your obligations under the lease, because this is probably the section that comes up the most. Who's responsible for fixing something when it breaks? If that something is inside the space, chances are it's a responsibility of the tenant. If that something is outside the space, meaning the parking lot, the exterior, the roof, or the foundation of the building, typically it's a landlord responsibility. However, the actual lease will control. The items that are in dispute most often are the major mechanical items. Air conditioners, furnaces, boilers, etc. Read the lease carefully, understand your obligations, as these things vary from deal to deal. Next, understand if your lease comes with a guarantee. What is a guarantee? Guarantee is when the tenant itself has its obligations guaranteed by another party. Most often in our context, we see it when the owner-operator of a restaurant guarantees the performance of a business. Meaning, if the tenant can't pay, the landlord has the right to go after the guarantor or the individual. Once you see you have a guarantee in place, there are ways you can mitigate as a tenant some of the teeth of the guarantee. Meaning, maybe after 3 or 4 years of good performance, you can lessen the guarantee. Maybe you can negotiate a clause that says if you sell the business or transfer the business, your guarantee goes away. Or, in worst case scenario, if you have to give the keys back to the landlord and your business doesn't work, the guarantee can get off the hook in certain circumstances. Next, we'll discuss assignment and subletting rights under a lease. An assignment is when you as the tenant choose to transfer the lease to another party. A sublease is when you as the tenant choose to carve off a portion of the space and allow someone else to occupy that space. In the context of a lease agreement, tenants want the most amount of flexibility. That is, they want the ability to transfer at will and not be limited by landlord's control. Landlords, on the other hand, want all the control. They want to know who you're going to be transferring to. They want the right to qualify them, etc. A happy compromise here is typically something known as a permitted transfer. That's when the landlord and tenant get together and they agree on certain criteria, wherein if those criteria are satisfied, then the landlord automatically approves the assignment or the sublease. Some examples of those criteria: creditworthiness, net worth, experience in the space, etc. That concludes our webinar for today, covering the main provisions in commercial leases you should be aware of. Should you ever have any questions regarding your commercial lease, please feel free to reach out to us. Our team is always here to help. Each situation is different when it comes to that structure. Depending on the preferences of the landlord and tenant, it can take the form, again, as mentioned, as a delayed rent commencement, meaning your lease will start. There'll be a period where rent does not start. And sometimes a landlord will prefer that method to kind of build back in some of the money that a tenant has to spend, and they'll offset it in the rent obligation. Other times, the rent will start when the lease starts, but the landlord will classify it as a rent abatement, meaning the rent will run, but that portion will be forgiven instead of not being due. It's a distinction, really one that the tenant may not care too much about because the end result is the tenant not paying. The third way that this works is through what's known as a tenant improvement allowance, whereby the landlord gives a credit, usually per square foot, to allow the tenant to build out the space. Some details here is that the money should really only be used for things that improve the space itself, not to buy stuff that the tenant will use in its business, right? Remembering back to the justification, the landlord is okay providing a credit because the money is going to improve the building. So using the money for things like a fryer or a hood won't be permitted, but using it for walls, painting, carpet, cabinetry will be permitted because those go to the structure themselves. Usually, the landlord allows for either one or two draws from the tenant improvement allowance, meaning the tenant will collect all of its invoices, all of its lien waivers from contractors, and a bunch of other technical items we can help you through, and they'll present a package to the landlord. The landlord will review that package and usually pay a percentage of or 100% of those costs if they're qualified. That happens usually once or twice throughout the course of the lease, mainly at the midpoint and when the work is done. Everything is negotiable in a commercial lease agreement. As we started the conversation with, understanding your leverage is super important when negotiating. There are a few things that turn off a landlord or landlord's counsel more than a party not understanding their leverage and not understanding the normal course of how negotiations go. For example, if your percentage of the shopping center is 5% of the total overall space, you're probably not going to have the same level of leverage as the anchor tenant being the supermarket or the large sports store. Understanding your leverage helps streamline the negotiations, and it helps the landlord take your revisions more seriously. What I mean by that, if you mark up a lease or if your attorney marks up a lease and the revisions are not in line with your leverage, it comes off as a bit disingenuous. It could cause the landlord or landlord's counsel to start to not ignore, but to really not take your comments as seriously, as compared to a very pointed review, very pointed revisions, given your scope and given the size of the project, that show the landlord you're serious, show that you understand where you fit into the piece of the puzzle here, and that you're able to really hone in on the issues that matter most. Usually that leads to a more efficient and more productive discussion with landlord's counsel, and ultimately gives you the best shot at getting to the best version of the lease for you. Great question. I think a letter of intent is very important for a number of reasons. The first of which, it allows the parties to understand the major issues that will come up in the lease. All of the things that we talked about today, from term to rent to use, etc., they're really best flushed out first. You don't want to spend the time and money and aggravation negotiating a long lease when you could have identified these issues up front and had the discussion with the landlord. Are these a go or a no-go at that point? It really just saves you time and effort. Things you should consider including in a letter of intent are term, rent, use, exclusivity, assignment rights if they're important to you, and repairs and maintenance clauses. Typically in these spaces, if a broker is involved, either on the landlord or the tenant side, the broker has a form letter of intent that they usually use. We always encourage you to involve counsel earlier than later. Many of our clients show us the LOIs first, allow us to make comments or at least observe and point out things that are there, point out things that aren't there, which is sometimes more important. We encourage our clients not to sign letter of intents until we see them. Although many are non-binding, it's important to remember that the parties do have expectations. So even if the letter of intent is technically non-binding, having counsel, or if you are negotiating yourself, trying to reverse those positions in the lease that were already agreed to in the LOI can prove to be very difficult. Yes. In our opinion, an attorney is necessary to review the document. We view it as an investment. We view it as something that you're going to have for you, being the lease, for 10, 15, sometimes 20 years if you love your location. The best case scenario typically we hear is that the landlord's a great person. I've known them for years. My father knew them. There's a great working relationship. You trust them. You trust the family. Perfect. It would be great. You never have to look at the lease. You pay your rent. Everything goes as smooth as it can. The worst case scenario is everything else. The landlord passes away. The landlord sells the business. The son takes over. The daughter takes over. And then you have to look at the lease at that point once the relationship is not there to prop everything up. Looking at the lease can be a sobering moment if that's the first time you really looked at it. Mandelbaum Barrett, with almost a century of experience in dealing with matters just like these, is here to help guide you through the process.